The non-heterosexual unions are entitled to protection under a constitutional scheme. I have referred to the necessity of recognizing what I've categorized as civil unions. The judgment of the Chief Justice notes the right to form union is a feature of Article 19 and 21. Therefore, the principle of equality enumerated under Article 14 and 15 demand this right to be available to all regardless of sexual orientation and gender. Having recognized this right, this court has taken on board the statement of the learned Solicitor General to constitute a committee to set out the scope of the benefits available to such union. I agree with the Honorable Chief Justice. I have referred to the Special Marriage Act and discussed the statement and object and reason therefore. From the above, the SMA postulates a special form of marriage available to any person in India, irrespective of faith. Therefore, SMA provides a secular framework for solemnization and registration of marriage. It is here that I respectfully disagree with my brother Justice Bhatt that the sole intention of SMA was to enable marriage of heterosexual couples exclusively. To my mind, the stated objective of SMA was not to regulate marriages on the basis of sexual orientation. This cannot be so, as it would amount to conflating the differentia with the objective of the statutes. Although substantive provisions of SMA confer benefits only on heterosexual relationships, this does not automatically reflect the objective of the statutes. I have said if the intent of the SMA was to facilitate interfaith marriages, then there would be no rational nexus with the classification it makes of excluding not heterosexual relationships. Then I've referred to the regulation of only heterosexual marriages would not be legitimate state objective, more so in cases where ex officio protected categories under Article 15(1) of the Constitution. However, I recognize, therefore, I have said that if this was so, the SMA would be violative of Article 14. However, I recognize that there are multifarious interpretative difficulties in reading the SMA to include marriage between non-heterosexual relationships. These have been enumerated in a significant detail in the opinions of both the Honorable Chief Justice and Justice Bhatt. I also agree that the entitlements evolving from marriage are spread across the proverbial spider web of legislations and regulations. As rightly pointed out by the learned Solicitor General, tinkering with the scope of marriage under SMA Act can have a cascading effect across these disparate laws.